Now, a lawsuit is essentially a dispute between parties that is brought into the judicial system for resolution. And the way in which this dispute comes into the court system varies according to your jurisdiction. Most state courts have their own particular court rules, but we can talk about the general principles involved in pretty much all of the 50 states for our purposes. And what happens in a lawsuit is the alleged injured party, known as the plaintiff, files a complaint. And in that complaint, they have to state allegations with particular facts and allegations involved. They also have to identify the defendant, and they should also be detailing the cause of action as to what it is that the defendant, the person who caused them harm, did or did not do that caused them harm. It could be a breach of contract issue, it could be a negligence issue, but they have to allege a specific cause of action that according to them means that the defendant should be held responsible. After that point, generally, a summons is issued and served on the party who caused the alleged injury and the defendant. Now, in a professional liability claim, generally that means that you're going to be in the defendant role. And you will get a summons. Hopefully, you have at least had some idea that this may be coming and that you've tried to resolve it amicably with your client, have gone through negotiation of some sort. But sometimes, believe it or not, it is a complete surprise to design professionals that a lawsuit has been filed against them. And if that is the case, obviously, if you receive a summons alleging that you are responsible for certain items that you did in your professional services, that is very obviously a claim, and you should immediately turn that over to your broker and us, the insurance company, and let us know that a claim has been made against you, because that is a demand for money, essentially, at that point. Or it could also mean that they want certain services. But essentially, at that point, that is a claim. And in a lot of places, you usually have 30 days to respond with an answer. And that answer, again, it's a very formal filing with the court. You either admit or deny the allegations. And if you do not respond in a timely manner, you are going to be hit with a default judgment that is in favor of the plaintiff. So if you are summoned, you need to file an answer usually within 30 days. And so, at that point, the clock is ticking. So you need to get your ducks in a row, contact your insurance company, contact your broker, engage an attorney, and file a response of some sort. It doesn't mean that you have to respond to each and every particular allegation within those 30 days, but you will need to respond somehow within those 30 days. It will generally be a denial of allegations, and then the process continues. Also, depending on the circumstances, the defendant may file a counterclaim. That is a counterclaim against the plaintiff, saying that, in fact, the plaintiff actually did not meet some of their obligations or did some things that caused them harm. So, it could go the other way as well. Or you may file a third-party complaint saying that there should be a third party being involved in this matter, and that they should be brought into the dispute. And then finally, you can also have a cross-complaint. If the plaintiff has filed more than one defendant at one time, you can file a complaint against another defendant alleging that they actually are responsible for this due to the particular facts and circumstances, and then you have a separate cause of action against that entity. As you can see, when we talk about litigation, it can be fairly complex